Hey everybody, Charley Egan here of the Egan Group at Hall & Chambers Real Estate. And this is another series, a video in the series that I do with my service providers and referral network. And I am here with Gerald A Tomsic of Tomsic Law. And the newsletter that's going out this month in February has to do with estate planning. And I wanted Jerry to come in and talk a little bit about the importance of estate planning and trusts in purchasing real estate, or if you have a home that's not in a trust, what he suggests you do. So, Jerry, you want to dive into that?
Thanks, Charlie.
Sure.
I think it's real important if you own a house or own any real estate that you have a living trust. Okay, the importance is you want to avoid probate. Now, let's just take the typical house of $600,000, let's say. If you have to go through probate, the legal fees are $15,000, plus you probably have assorted costs from the court of a little over $1,000, $1,500. So you can avoid that with a living trust. If you had just one house, typically we charge $500-$600 to change the trustee or whatever, and that's your only expense. So it's a huge savings. So it's very important that you consider using a living trust if you own real estate.
So minimally, it's going to be $16,000 to $17,000.
Okay, the probate statutory fees are 4% for the first 100,000, 3% for the second 100,000, and then it goes down to 2% up to $1 million. Beyond $1 million, it's 1%. So you can see if you do the math on a $600,000 home, you're at about $15,000.
Okay.
And the court costs keep going up. The court didn't used to charge you for filing a will and that. Now they charge you $60 for filing the will and stuff like that. So and they're always raising the filing fees. So in addition to the fact that it can be very slow sometimes. I think they've gotten the calendar a little bit under control, but a year ago it was 6 to 8 months before you could even get on calendar.
Oh, you mentioned that before. Yeah.
So
for you to put a home that's, say, just vested as husband and wife or community property, and they come in and you put it in a trust, it's typically does it depend on the price of the property, or
no? It does. No, we do have to prepare a living trust, and then we have to transfer the title to the house.
Yeah.
So if it's a husband and wife situation, we're generally charging somewhere around $1,400 for all the documents, which would be the living trust, a will, pour-over will for each spouse, and health care powers for each spouse, and a durable power of attorney for asset management.
Okay.
And then we charge like $300 for the will, the deed to transfer the property to the trust.
And that's with the Charley Egan discount, right?
Yeah, that's generally our rates are fairly low. I hesitate to put them out there because some attorneys were criticizing another attorney that was charging that same rate.
Yeah.
And I didn't say anything. I just said I'm charging that. I didn't want to tell the other guys that I'm charging that too. So
yeah.
So
Jerry has done my estate planning for me, and I send all my clients to him. I've known Jerry for 10 plus years, so that's great. Is there any other details about real estate? Estate planning?
That's probably the main thing with real estate. You can. The other thing that's real important in doing your estate planning is to have your beneficiary designations on your retirement plans. And that I have a case right now, which it's a mess trying to figure out because they didn't have the beneficiaries listed on the plans. So actually a lot of those plans that would have avoided probate have to go to probate now.
Okay.
So it's good for my billing, but it's not good for the client. And we got a lot of them excluded from the probate, but we still have quite a few of them in the probate.
Okay.
So it's, and the other thing I noticed on Charlie's newsletter, everybody has this rumor that if you don't have a will, your property goes to the government. Yeah, that's not true. But your property, if you don't have a will, then it goes by the statutory scheme set up by California, which means it goes first to it goes to your spouse, then, and depending on if it's separate property, it may go to your spouse and children. And then if you have children, it goes to your children. If you have no children, then it goes up to your parents. And then if it's not your parents, it goes to your brothers and sisters. So that's the basic scheme. So you probably, a lot of times people have something else in mind, and it's best for you to delineate what you want to have happen.
Otherwise, it defaults to that
It defaults
sequence.
to that sequence, exactly.
Okay,
So,
okay. That's
yeah.
important.